We're going to pivot here, transition to our next guest, our final subject of the day. Andrew Crocker is a political science instructor with OTC, Ozarks Technical Community College, and he joins us the first Thursday of every month. Can't believe it's the first Thursday in July already. But Andrew is here. He's on the phone. He is on the yacht in Florida, I believe.
I am I'm in a very drab conference room.
Oh.
But I'm in a very drab conference room in beautiful, sunny Gulfside, Florida. So I'm having a good time.
Nice. Vacation or work?
Yeah.
Or
vacation. A little bit of both. You got to always keep one foot in the teaching world a bit. But for the most part, just walking the beach and getting around to the water and playing with the wife and kids and extended family. Saw a great fireworks show yesterday. How was your fireworks, Steve, yesterday?
You know, my son put on quite the display. It was pretty good, yeah. And our neighbors, I tell you what, it sounded like we were in the middle of World War III with all that was going on in our neighborhood last night. It was beautiful to watch, fun to watch, and enjoyed being outdoors last night.
Well, yeah, I assume you live outside of Springfield then, with all the crazy fireworks going on, because those fireworks have no holds bar outside the city limits. They really do go crazy. I had relatives that live in Battlefield, and it sounds like a battlefield on the 4th of July. It's pretty crazy.
Pretty crazy. Want to talk to you today, Andrew, and was thrilled to see your text earlier this morning about what you want to discuss, because it's timely, and that's the purpose of this show, and how do we take national topics, big topics, and break them down into how it affects us locally here. So Trump's Supreme Court list, he's got a list, he's narrowed it down to 3, 2 men and a woman, that he wants to recommend, interview, get down to brass tacks, and he'll nominate one of those 3, we think. It could be somebody else, but these are the 3 we think they will be. So my question to you, because when you come on, we talk about the Constitution, is what does the Constitution have to say about Supreme Court justices? When did all this... How did we first come to have a Supreme Court and Supreme Court justices? And then ultimately, before we let you go today, are Supreme Court justices today bound to the U.S. Constitution the way our forefathers wrote it, interpreted it, and intended it to be? Or are we at a point now where it's okay to blend it into our current culture, situations, and modify it so that it reflects who we are today? So I'll give you my 3 questions up front, and you can take it and run with it.
Well, I just want to start off with what the Constitution actually says about how the court system is to be structured. All the Constitution says is you need one Supreme Court, and Congress will figure out all the inferior tribunals, meaning Congress can set up the court system, the number of courts, the number of judges. They can do that. Congress has pretty much absolute power to do that. But as far as what we know as the Supreme Court, it's a completely different animal in the 1700s. Matter of fact, in the Constitution, the word supreme is lowercase. They didn't think of it as this proactive defender of the Constitution against federal laws. Now, that's how you and I think of it. Right. If the United States Congress passes something saying no brown T-shirts are allowed anymore, the Supreme Court jumps in and strikes that down as a violation of free speech. But back then, at the time, the Constitution was a lot of things. Primarily, it was a reaction against the failed Articles of Confederation. And the Articles of Confederation said that the states basically could call their own shots. And so now you really had a nation of 13 states like herding cats. They're all doing their own things. And the court system doesn't even really exist if there is a major debate over the Articles of Confederation. It's actually settled in Congress, not in the courts, believe it or not. So then we get rid of the Articles after about 10 years because it failed. And we come up with a Constitution and a court that's job is to basically slap the states anytime they want to do their own thing and violate the U.S. Constitution. So that's what the Supreme Court was originally designed to do, slap down states for trying to get creative, do their own thing, act outside of our federal constitutional order. And really, initially, the Supreme Court wasn't even thought to be that significant. John Jay was our first Chief Justice of the Supreme Court. And John Jay as you know, this position is a life term, and he stepped down after about 6 years to run for governor of New York. So that's how low the Supreme Court, relative to today, was considered. And so that's what it does for a while. It just kind of shoots down. It deals with the individual cases. It only has 6 judges, so there are lots of 3-3 ties. And it just deals with smaller issues. And it's not until the next century or so Congress starts bogging down. Congress, as you know, is messy to begin with. And the courts grow in size. You now have hundreds of judges rather than just a couple dozen. And these hundreds of judges, as you know, anytime you increase any bureaucracy, people want more power. And the courts start taking more power for themselves, saying that we are now the arbiters, the final arbiters of what is constitutional and what is not constitutional. And that starts around the 1800s. So that's about 100 years after the Constitution is passed. And it just kind of evolves into the situation we are today, where the Constitution, where the Supreme Court is a cudgel for the Constitution. Any federal laws, not just state laws, but federal laws that are deemed unconstitutional are frequently, not occasionally, but frequently, dozens of times a year, struck down by the Supreme Court if they deem it to be out of step. And so that's why the Supreme Court has become such an important part of our everyday life, and the retirement of Kennedy such a big stinking deal.
We've had the conversation the last week or so. And I don't have the language in front of me, but there are things that Supreme Court justices can write about cases that are in front of them. One's an opinion, and then the other is not a concession, not a conclusion. I forget the term.
Right. They have in a Supreme Court opinion, you'll typically have 3 parts. You'll have the majority opinion, which is the only part of the opinion that matters. That's them saying, we are ruling for this party, or we're ruling against this law, whatever. That is their ruling. However, judges are divas, and as a result, we give people that disagree with the conclusion their own platform to complain. So you'll have dissenting judges who disagree with the ruling, and then you'll even have concurring judges that'll write concurring opinions that'll say, I agree with what the court has ultimately decided, but I disagree with some of the reasoning. Here's what I would have preferred us to say instead, even though I agree with how the court ended up on the issue.
When Justice Kennedy announced his retirement, just prior to that, he had written some concurrences, which really many are interpreting now as kind of a prelude to who replaces him. It was an indicator that he was going to resign, and to whoever his replacement was going to be, here's how you should use your position on the court and how you should, rule. So I don't know if you've had any time to embrace any of that or wrap your brain around any of that stuff or even seen that, but kind of interesting that he would kind of foreshadow his resignation, his retirement in that fashion, if that's accurate.
Yeah, and the one thing that's real interesting about Kennedy is that he is politically conservative. That doesn't surprise anybody. He is politically conservative, but he's also what some people in the law community call temperamentally conservative. He's temperamentally conservative. He believes in incrementalism. He was, so long as he was going to be on the court, just to talk about the issue everybody cares about, he was never going to overrule Roe v. Wade. Not his style. He doesn't believe in gigantic radical change, even though he did cast a few votes for radical change. Instead, he believes in slow, gradual molding. He believes if you do things in an incremental way, the impact from them will last longer, because quick fixes can be undone quickly. Mm-hmm. But if you gradually chip away, and you've seen this with abortion law in this country, abortion is legal, but it has been increasingly restricted in a lot of states and in a lot of ways that Kennedy himself approved. Now, his approach to conservative temperament is not shared by hardly anybody on the Supreme Court, on the liberal or the conservative wing. They are all very aggressive at attacking laws they don't like. They take no prisoners. They are not temperamentally conservative. They have no qualms with jumping in with both fists and beating up laws in the totality that they don't like. And that means that once Kennedy leaves, while I don't know if the new conservative judge will rule that much differently, in that the new judge will also be conservative, but you're going to see a lot more conservative judges being willing to attack laws they don't like, and I think liberal judges have been that way for a while themselves. So you are going to see a culture shift, I think, in the court, even though the rulings might still be very conservative.
Visiting with Andrew Crocker, political science instructor at OTC, Ozarks Technical Community College here in Springfield. We're going to take a quick break, real quick break. We'll come back and get into more with Andrew Crocker when we return here on the KICK Morning Show, presented by Priority Pest Control. We'll be right back.
This is Kathleen Odell with the Springfield Greene County Library District. We're at thelibrary.org, and you're listening to the KICK Morning Show, 92.3 KICK.
Thank you, Kathleen. She'll be with us on Monday. We'll talk about all the things coming up at the Springfield Greene County Library. If you've got youngsters who are bored, you're looking to do stuff on a budget, how about free? They've got all kinds of activities going on, so we'll talk about that on Monday. 8:55, our guest is Andrew Crocker, political science instructor with OTC. Here in Springfield, we're talking about the Constitution, very timely issue with the U.S. Supreme Court. Andrew, I want to ask you quickly about the Roe v. Wade discussion, because in my thinking, in my mind, overturning Roe v. Wade is not as simple as having a 5-4 majority. That's been the law of the land for a long time. Sure, there will be a case come up shortly that could get to the Supreme Court and challenge that, but how likely is it really that we're going to overturn Roe v. Wade, even if we had a 5-4 majority?
I don't think it's as likely as a lot of hardcore conservative cheerleaders might think it is. I think if you have 5 hardcore conservative jurors, it sounds like we're about to, on the Supreme Court, it's conceivable that they could flat out strike down Roe v. Wade. It's just not likely. The Supreme Court, regardless of its partisan political makeup, doesn't like to flat out overrule previous rulings. It doesn't like to do that, because once you start doing that, it's like opening Pandora's box, and your rulings that you rule today can get flat out reversed a decade down the road.
Right.
They don't like doing that. What they prefer to do is, make tweaks or make adjustments. That's typically what they prefer to do. Now, Kennedy was like the number one cheerleader for that approach, being incremental, being a tweaker, being a adjuster, and not being a flat-out reverser. It's unclear if we add another hardcore conservative judge if that will change the nature of the court. But I believe the court, while it might be more aggressive against abortion rights, very unlikely for at least a long time to outright overrule Roe v. Wade.
Well, I think given today's climate, our culture, and our country right now, the country would come unraveled if that were to happen, if they overturn Roe v. Wade. Let's go on to my third question for you. The Constitution today, Supreme Court justices, the way they rule, should they be held to rule by the Constitution, or are we at a point in our country where we just say, no, it's a different time, different place, and we need to adjust our thinking as far as Supreme Court rulings and the Constitution?
Well, their job description is to rule and rule on the basis of the Constitution and be very, this is going to sound silly, but be very judicious towards how the Constitution is applied in laws. We are at a point, however, have been at a point now for maybe since the 90s, maybe the 80s, where courts are getting a lot more creative in their interpretations of the Constitution. In a way, they have to, because the world is a lot more different now than it was before. For instance, when the Second Amendment was introduced to the Constitution, we didn't have machine guns. Or we just had a Supreme Court ruling on Fourth Amendment rights, which are protections from searches and seizures. The founders had no idea that cell phone towers would even exist, obviously. And so courts do have to get a lot more creative in applying these 1700 year 1700 standards to 21st century problems. And in a way, that flexibility does kind of lead to a Supreme Court now that they have their ideas about a certain how the Constitution should be interpreted, and they get awfully creative in noodling opinions that will ignore or skip over or flat out deny entire parts of the law or our country culturally that may exist in reaching the conclusions that they want. So I do think we end up with a Supreme Court with a lot more wiggle room and a lot more leeway than perhaps the founders intended.
I wish we had another hour to talk about this because it feels like we just kind of scratched the surface, and we may, I don't know when you come back, we may try and find another pocket of time before you come back on a month from now to talk about it. So, Andrew, appreciate
Steve, we say that every time.
I
Steve,
know.
we say that every time. Every time we get together, we always want another hour.
I know. Well, maybe this is the month we make it happen.
Maybe. Let's talk about it.
Enjoy your time in Florida.
Thank you so much, sir. Have a great one.
You bet. Andrew Crocker, political science instructor at OTC. It is 9 o'clock KICK AM Springfield, the KICK Morning Show presented by Priority Pest Control.